Hi, welcome to Legally Speaking. I'm Aidan Brown, and we're back here again today with one of our resident experts, Zinhle Mavuso from Popela Maake attorneys. And we're here today to talk about making a will. And this is one of the most important things that you can do for your loved ones and the people that you care about. We all know we're going to be dead anyway, and what we do is we in some way justify that we're not going to go out and make a will. Like, it's kind of like pushed to the back of our mind, not our problem. Well, that's a pretty selfish way to go out of this world, because it's going to be your family's problem, it's going to be your loved ones' problems, and you could really make a mess of your legacy. Families get ruined over this kind of thing. Businesses get torn apart, people lose their livelihoods and incomes. The responsible thing to do is to make a living will, especially if you've got assets in a family and people that you're looking after. And it's quite a complex thing to do if you don't have some kind of legal training or you're not familiar with the law. And that's why we have Zinhle here. She's going to help us go through the various steps, talk us through the processes, give us a little bit of advice, and tell us exactly how to make sure that our wills are read out, that they're honored when we die, or when a loved one dies, their wills are honored when we have to make the claim. And this is something so important. So let's hand it over to Zinhle. We've got a family member and they need to make a living will or a will in case they die. Mm-hmm. What do they do?
So firstly, wills are regulated by the Wills Act in South Africa. And whilst the Wills Act doesn't necessarily prescribe what you're supposed to put into the will, it prescribes the formalities of what would make a valid will, right? Because at the end of the day, the will is there to reflect your intention, your desires, what you want to have happen to your estate when you pass away, right? So that's for your freedom. You can do what you want. So in terms of the formalities of what will make a valid will, first thing you need to know, a copy of a will is not a valid will. So what I would recommend is that you sign a couple of original copies. So make multiple copies, sign them physically, so that there's more than one original copy in play, in case, so that, if a house burns down, you don't have the one copy just there, right? What I would also recommend is that you can keep it in like a safety deposit box. You can keep it with the bank if you got assistance of making the will through a bank. If you use the law firm, they can keep the
so a bank,
well.
So you can do it yourself, and you can make multiple copies and put them in various places and inform family members and that kind of thing.
Yes.
Or you can go to a bank or a law firm.
Yes.
Okay, so there's three options. Cool, that's great.
Even your insurance providers as well can help you with drafting a will. They can also keep your original copy there with them as well. So for purposes of the valid will, it has to be in writing. It has to be fully signed by the testator being the person that's making the will. It has to be signed fully at the end. And what I would also recommend is that where there's more than one page to your will, that you initial each page of that will as well, right? So a person can make a will from 16 years and older, so long as you understand the nature and content of what a will actually is, right? And the will has to be witnessed. Your witnesses also have to be competent. I think the minimum age is about 15 or so that can sign, but you have to make sure that if you stand to inherit in terms of that will, you cannot be witnessing that will. You'll get disqualified, right? Because it'll look as if you try to force someone or influence.
It could be extortion.
Do you understand?
It's a bit
So make sure, if you're bequeathing your car to your son shouldn't be typing or writing that any portion of that will. They also should not be initialing as a witness that will.
You should use a neutral actor.
Of course. Can be anybody. All the witnesses need to do is sign fully at the end.
Of course, that makes sense.
Basically
two witnesses?
Yes, two witnesses. Has to be a minimum of two witnesses. They just sign fully at the end. If you can't sign, so we do have an issue of illiteracy here in South Africa. So if a person doesn't know how to sign their signature or sign their full name, you can mark the will with an X, or you can use your thumbprint as well when you're signing the will. Or you can even ask someone else to sign it on your behalf. But when that happens, you have to do that in front of a commissioner of oaths. The Commissioner of Oaths must look at the will, make sure that this is the will and testament of this person, and that they have indeed asked someone else to sign on their behalf, and then it's signed in front of them in front of them, the commissioner also certifies. That is what will make your valid will.
Signing of the will is obviously a very important factor in this, because you've mentioned even if you make multiple copies, sign each copy so that each one has an original signature, an original date, etc., etc. So obviously, that's a very significant factor. What other significant factors are there?
So it's not necessarily a requirement, but date your will. It may come off as you being finicky, but what happens is, let's say you make a will today, you didn't date it, you've made all the formal requirements of it, but you haven't dated it. Someone else, for whatever reason, may come at the forgery, or you made a will later on, or whatever it is. Now we sat with which will came first, which one came after. Right? Because in a standard will there is a revocation clause. So you're saying that any wills that you made before stands to be revoked. But then when you don't have a date on your will, it becomes difficult to determine which one is the older one, which one is the newer one, right? So it might seem a small point, but please make sure your wills are dated, just to make things easier for the parties going forward later on.
And that's for just generally making a will. What advice have you got if somebody would like to make a will to their bank or their insurance provider, for example? Is there any particular advice around that process?
So, I mean, they would take you through that process themselves, right? But and it will be linked to whatever policy that you have. So, for example, you have banks that provide legal aid, like your legal wise and that type of thing, right? So you paying your bank a minimum fee every month to provide you with legal services. You can approach them, hey, you're providing me with legal services, can I please get a lawyer to help me draft my will? And then they'll take you through that process as well. Or the bank themselves will say, yes, we have a department where they can draft the wills for you. They'll give you an example. They'll take you through what type of assets do you have that you'd want to list there? What do you want to happen to them? What are your funeral directions? How do you want to be buried? Do you want to be cremated, etc.? And then they would be able to, once you've completed the draft, they'll send it back to you, you sign the original, and then they take the original. And then being a bank, obviously, they would be maybe better suited to then keep your original copy with you. But then also keep a copy for yourself.
Yeah, always keep a copy for yourself.
Always keep a copy for yourself.
And then obviously you'd want to have your loved ones know where to find the wills in the event of their death. And then I was wondering if you could talk us through when you're actually now drafting the will. Mm-hmm. Talk us through some of the roles, like maybe the role of the executor of the estate, for example.
So the executor would be the person that gets tasked with making sure your estate is administered the way you want it to be, right? And whilst you can't specifically appoint the executor, mm-hmm. because the appointment of the executor lies within the jurisdiction of the Master of the High Court, what you can say in your will is that this is the person I would like to have nominated as my appointed as my executor mm-hmm. of my estate, right? And then what I would also recommend is that you put a clause discharging the executor that you want from providing security. What that means is that in order to make sure, for the master to make sure that you are administrating the estate properly, what they'll require of you is they say you need to put up security. So put your money where your mouth is to make sure that this estate is dealt with fairly and equitably, right? So you can exclude that requirement on your executor as well, which I would recommend. People don't have that money to put
yes,
up
of
front,
course.
So make it would be a good idea for you to put such a clause that excludes your executor from providing your. And
what kind of person would you choose to be the executor of your estate on your will? It
has to be someone that you trust. Listen, yes. With great power comes great responsibility, and when you're appointing people as your executor, you're giving them a lot of power over what they can do. Obviously, not obviously, but people tend to change afterwards. Yes. So make sure it's someone trusted. Make sure that you can that they will be able to do your estate justice. So it can be a family member, it can be a friend, it can be whoever you want to be. In terms of instances such as where maybe you use the bank to help you draft your will, the bank would say, yes, we would want to be appointed as your executor. Or even your insurance provider would also say, we would want to be your executor. Because then there's that fee of the 3.5% that they would be entitled to.
Yes.
And after the administration of the estate.
That makes complete sense. Yeah, look, nothing's for free when it comes to banks and insurance companies. So that's an interesting point, that they're obviously going to come in and take a portion of your estate. So just bear that in mind when using a bank or an insurance company to undertake your will, because they might want to take a cut out of what your inheritance is to your family, and you might want to be concerned about that, or at least check what the kind of numbers are, because that could be quite concerning. Look, in the end, you have to know that the responsible and right thing to do for your loved ones and yourself and the general harmony of everyone around you is that if it's the end of your time and you kick it, make sure you've made a will. There's a number of ways that you can make the will. You can do it yourself. Make sure you sign it. Make sure you date it. Make a number of copies. Sign all those copies originally. If you need assistance, a law firm can help you out. An insurance company can help you out. A bank can help you out. The law firms will obviously take a fee up front, and that would be the end of that. I suppose that's how it works, more or less.
Either way, because then we can also agree that there's a 3.5%.
Oh, okay. That you could also take in a fee afterwards.
Yeah.
And they would obviously help you set up and administer the whole process. But you need to have one, and that's the most important thing. Number of options to undertake it. And then the final piece of advice, obviously everyone needs to know where they can find the copies of your will, but the executor of your estate should really be somebody that you trust, somebody that you think is morally and ethically upstanding, somebody that's going to have your best interests at heart, your family's best interests at heart. This is an incredibly important process. Make sure the paperwork is done right. If you're not sure, contact an institution like Popela, Maake attorneys, or your banking provider. Pick a good executor and do it in good faith. You've been amazing. Thank you so much for your advice, and thanks for being on the show today. That's Legally Speaking for now. Catch you guys later.